Welcome to Turn Talk. I'm Jim Chance, Senior Judicial Education Attorney at the Federal Judicial Center in Washington. In each 8 to 12-minute episode, we discuss the Supreme Court decisions likely to have the greatest impact on the lower courts. Joining me are Erwin Chemerinsky, Dean, and Jesse H. Choper, Distinguished Professor of Law at the University of California, Berkeley, and Tara Grove, Vinson and Elkins Chair in Law at the University of Texas, Austin. Thank you both for joining us today. Today, we're discussing 303 Creative versus Elenis. This case asks whether public accommodation laws can compel expressive speech and helps define expressive activity itself. Or put a different way, does the First Amendment provide a basis for exemption from anti-discrimination laws? Tara, the court accepted cert on the First Amendment question only, but religion did play a role in the facts. Can you help us understand the facts and the issues surrounding this case?
Right. So one of the things I want to start off with is that the court relied on a set of stipulated facts. So the plaintiff, Lori Smith, and Colorado kind of agreed as to what the facts were on the ground. There's been a lot of reporting in the press that maybe those were not the actual facts. But as lawyers, we know that oftentimes we're stuck with the stipulated facts that our trial attorneys decided to agree upon so that the case could go forward on the law. So I'm going to describe the stipulated facts. Under those facts, Lori Smith had a website business that she was going to expand to include wedding websites. And she said she did not want to include wedding websites for same-sex marriages. She said that she would serve people of various sexual orientations and gender identity doing other things like birthday parties, but she did not want to put forth a same-sex wedding website on her site. And the parties also agreed that any website that she created would be in part the expressive conduct of Lori Smith. Now, all of this goes to the free speech issue. As you pointed out, there are religious undertones of this. Lori Smith said that her objection to same-sex marriages was based on her religious convictions. And nonetheless, the court did not grant cert on any free exercise challenge and granted cert only on the free speech challenge.
Erwin, how did the court analyze the case?
The Supreme Court, in a 6-3 decision, with Justice Gorsuch writing for the majority, ruled in favor of Lori Smith. As you and Tara pointed out, the Supreme Court focused only on the First Amendment speech question. The court did not grant cert on or discuss the free exercise religion question. Justice Gorsuch's majority opinion focused on this as compelled speech. He went back to the Supreme Court's landmark decision in West Virginia Board of Education versus Barnett and said that compelled speech violates the First Amendment. He said this would be compelled artistic speech, that Lori Smith was doing customized, individualized websites that was her expression, and to force her to engage in expression against her beliefs violates the First Amendment.
Tara, the dissent apparently saw this differently. Tell us about that.
So I think the dissent was extremely concerned about what this decision means, not just for this case and Lori Smith's particular website, but what it means for anti-discrimination law more generally. So traditionally, it has been the case that states could ban discrimination on things on grounds like race, sex, sexual orientation, gender identity, a variety of different circumstances, age. And if someone discriminated, if someone decided to open a business up to the public, that business had to be open to everyone. And this decision seems to call that into question. Because if Lori Smith can say she has either a religious conviction that opposes same-sex marriage or just some other conviction that opposes same-sex marriage and refuse to do same-sex wedding websites, what about interracial websites? In fact, during the days leading up to Loving versus Virginia, the case that said states cannot ban interracial marriage, one of the grounds for opposing interracial marriage sounded in religious convictions. And though many religious people would find that an abhorrent conception of religion, that was still one of the grounds that was argued. So if Lori Smith can refuse to have same-sex weddings on her wedding website, what about interracial marriage? What about a variety of things in our society that some people find offensive or problematic? Now, one might be able to read the majority opinion narrowly, and I think there's a lot of discussion right now about how narrow it was, but the dissenting opinion took the case for what it might mean and said it could undermine anti-discrimination laws around the country.
Big picture, what are the takeaways?
Those engaged in expressive activity can violate state anti-discrimination law when they're providing service that would violate their beliefs. As Tara said, this isn't limited to just religious beliefs. And as Tara said, this isn't limited just to discrimination based on sexual orientation. The crucial question that's going to be litigated in the lower courts is, what does expressive activity mean? And Justice Gorsuch said the court wasn't going to address that in this decision.
As always, it's been a pleasure. Thank you both for sharing your thoughts with us today.
Thank you.